Those policies are great. I only lived like a month. Living on the younger boy. The older boys.
You can't say sleep, okay.
Everyone's thought it was.
We didn't use the parking lot.
After. For no reason. just go running out of the yard. Like, and then we got his wrestling. She's not doing the 7-on-7 control. He started at his first year. And he's a couple good guys.
You have Jake Mercer?
He started.
Yeah.
Pretty cool. They come in, they see his record, and they beat him, they don't realize it's better. Oh, yeah. You don't have a temple beside you, you're it.
Yeah, I was actually like, I'm thinking about it.
No, don't have any fights. Hopefully this is the same day.
I have the.
Just here, just in case.
Just your pride. Yeah, he said he might get one.
Kansas State.
Very good. The savings tax. One thing that's wrong, Sammy, football.
Only on the day.
Yeah. Good coach. Well, good luck.
Well, they're, I didn't get one as far as. Yes.
That's really what they should do. Suspend the argument. Go hard.
All right.
Thank you. You may be seated. Welcome to this afternoon's session of the Kansas Court of Appeals meeting here in Topeka. My name is Catherine Gardner, and I'll be serving as the presiding judge today. On my right, your left, is the esteemed Stephen Hill, who is the longest sitting judge in the state of Kansas, been on the Court of Appeals many years. And on my left is Judge Joan Loudon, who is the chief judge of the Leavenworth area. It's the first judicial district, and we're happy. She's one of the district court judges that's sitting with the Court of Appeals this month. So we are your bench. We have 3 cases set for oral argument. I believe all 3 are 15 minutes per side. And so without further ado, we will go ahead and call the first case of Sergio Martinez versus Haverkamp Brothers, Inc. and Redwood Fire and Casualty Insurance Company, number 128693. And counsel, when you're ready, I'll take appearances, please.
Brent Jepson on behalf of the appellant Haverkamp Brothers and their workers' compensation insurance.
Thank you.
Jeff Cooper on behalf of Sergio Martinez and the appellee.
Thank you, counsel. Appellant, you may begin and let me know if you'd like any rebuttal time.
Thank you. I would ask to reserve 3 minutes.
3 minutes is granted.
May it please the court. Again, my name is Brent Jepson. I represent the appellee. This case really comes down to an interplay between a 2015 injury, which is not part of this case, and the 2020 injury, which is part of this case. And the reason why that interplay exists here is because you have a situation where a claimant gets hurt to their left knee and their left hip. It's not an insignificant injury. It's a significant injury from the standpoint that they underwent surgery to both the knee and the hip. They have permanent restrictions for the knee and the hip. That injury or those injuries resulted in a substantial settlement to the claimant. That settlement occurred during the pendency of this case. During that pre-existing case, the claimant was on accommodated work duties, which required him to basically do some cleaning, light work, not his usual job duties as a breeding technician.
So when he was on light duty, he did not do any breeding
He
duties?
did not. What he
That was consistently from after his injury in 2015 until his 2020 injury?
Yeah, and on the day that he was injured, in this case, in the 2020 injury, he was doing his cleaning job duties. He wasn't doing the breeding tech job. He hadn't done that for some time. Essentially, this was during COVID. The employer needed different things cleaned up. They had some data processing, computer entry work that needed to be done. So that's what they had him doing. Wasn't doing his usual job duties.
Did the usual job duties include the barn?
He would have been, I believe, in the barn, which is where they do the breeding job.
Was part of the permanent work restrictions from the 2015 injury, though, that he not be in the barn?
I don't recall that being a permanent restriction that he couldn't be in the barn from the 2015 injury. No.
So he was working in compliance with his permanent restrictions from 2015 at the time he was injured in 2020?
He would have been within those 2015 restrictions. And again, those became permanent restrictions effectively before this injury, but they carried through this injury because, again, those are permanent in nature. Those continued through. But he then has an injury in this case. That injury isn't significant, I'll say, because objectively, you look at it, what he testified to is as he was going down a small set of steps, he believes either his leg gave out, his left leg, or he may have tripped over something. He wasn't entirely sure, but he fell. When he fell down those stairs, he didn't fall onto his back or his side. He fell onto his feet. When he fell onto his feet, that's when he says he felt a hot sensation in his back, like it was kind of burning. And my client provided treatment for that injury through Dr. Wheeler, who he saw. Dr. Wheeler gave him an injection, but he really didn't need anything further. He then saw Dr. Hess. Dr. Hess had indicated, who was the claimant's hired IME. Dr. Hess indicated a surgical consult, but that was never done because the court then directed the parties based on two separate opinions to go to a neutral IME, which was Dr. Gardner. Dr. Gardner found that this was an exacerbation of his pre-existing lumbar spine condition, not a new injury. And so no treatment was recommended by Dr. Gardner for the work injury. The court wasn't, or the administrative law judge wasn't satisfied with that opinion. So he was then sent out to what would be a fourth doctor, Dr. Jones. Dr. Jones, too, did not recommend treatment for Mr. Martinez. He determined that he was at maximum medical improvement. Dr. Jones also didn't say that the claimant would need future medical from our work injury. So what we have here, four separate doctors who have seen the claimant, effectively a result where you have a claimant with what would be, for all intents and purposes, a 5% functional impairment, not significant in itself. And 3 out of 4 doctors who've indicated that he doesn't need any future medical from this injury. What then happens in this case is we have that 5% functional impairment. It turns into a 20% work disability at the administrative law judge level. It then turns into a 50.5% work disability at the appeal board. So this case has exponentially grown throughout the course of the litigation on it. But what I want the court here to understand is when you look at the context of how we get to that result must be reversed. It does not make sense under the law, and it does not make sense under the facts that are applied to that law. The appellant contends in this case that the board erroneously applied the law and interpreted the law as it applies to wage loss and task loss, and that the board erroneously interpreted and applied the law as in regards to future medical. Those are the 3 issues which will be laid out, which I know the court has read through our brief on that. But there are some things that I want to highlight on each for the court's attention on that, where I believe that it comes down to the crux of this case.
Well, what's the best argument that you have?
I think the best argument is if you look at the language of the statute and you apply the language of the statute, The board decision cannot stand.
Why?
And it
Explain
cannot, as to wage loss, it cannot stand because you have to look at what wage loss is caused by the injury, not wage loss generally. And what the board found is that the claimant has a 61% wage loss, but there's no comment that it was caused by the injury because it cannot have been. As the task loss, it's the same argument. You have to look at what task loss is there that's caused by the injury, not just what wage loss does the claimant have, but whether that's caused by the injury. And the board does not provide an analysis that falls under that statute.
What would you have us do as a remedy?
I think that the decision should be reversed of the board. I think if you look at the administrative law judge's award, which is part of the record in this case, you can see that the administrative law judge provided a much more thorough analysis under the statute. I think that there are still issues with the administrative law judge's decision in terms of finding this to be a work disability case. But again, if you follow the statute, effectively, what we have here again is a 5% functional impairment case with no future medical. At best, what the court has before it is the 20.2% work disability, again, with no future medical, which is what the administrative law judge awarded in this case.
Your main beef with the wage loss issue is that this employee was terminated for cause, correct?
That's part of it.
That's part of it. So if I just focus on that part of it, it seems like for cause means different things in the law in different situations. I mean, here, it seems like all that it means is that the employer had a reasonable explanation or a good reason to fire them. It doesn't have to be job misconduct. It doesn't have to be egregious, disloyalty to the employer. It just has to be a reasonable excuse, I might say, for terminating this person. Is that correct?
That's basically correct. And I don't think it's not necessarily an excuse such that the employer just comes up with, oh, here's our reason. They have to have a good reason, and it has to be reasonable as to why they terminated the person.
Mm-hmm.
Yeah. But sorry, I didn't mean.
Not pretextual. Yeah.
It cannot be pretextual, exactly. And that's part of the decision too, is that there cannot be evidence that the employer was just using that as a reason to get rid of the person to avoid benefits.
Right.
There's no evidence in this case that that Haverkamp was trying to avoid benefits. What they had is a claimant who was not showing up to work consistently, which I think is a valid reason for any employer when the employee is not consistently showing up. And when you have someone who tells their employer, hey, I'm not going to do half my job anymore.
Well, was he ever disciplined or warned, or does he have a record that you told him you better show up on time, or this will be the consequence? Any type of progressive discipline or warnings in the record?
I don't know that there was evidence in the record of a progressive discipline policy or that one was applied to this case. Certainly, this is an individual that Haverkamp had tried to work with in the past. They obviously tried to keep him around during COVID and have him do accommodated job duties. Ultimately, they hired him as a breeding technician, and that's what they needed him to do.
But I do have a question about that. And this goes to my earlier question, I think, because I found it in your brief where you indicate that Christine Keim, who is the HR representative for Haverkamp, and I'm looking at page 4 and 5 of your brief, that after the 2015 work injury, she testified that when he returned to work after the 2015 injury and subsequent FMLA leave, employer found a job which accommodated his permanent work restrictions. Employee could not work in the barn since he could not work on uneven surfaces. And you're saying that for cause is that he's not completing half or more of his job duties, but it looks to me like this still goes back to his permanent work restrictions.
From the 2015 injury.
Yes.
And that's again where I say whether he could not work in the barn or not, I think that would be an interpretation of what uneven surfaces would be and how that arrangement would be.
Well, that's your HR individual, correct? I mean, that was her testimony or her information based on your brief.
Right. And their testimony was that they could have continued him working in that job, in that capacity, had he decided that he was going to do so, but he didn't. Does that make sense?
You're saying he could have been working by breeding pigs?
Right.
That was the testimony from the employer, is that they could have had him continue doing that job duty under the prior restrictions. But he decided that he was not able to do that, or he felt that he was not able to do that, so he didn't.
But didn't they move him out of the breeding position because of the restrictions?
While he was in treatment for the 2015 injury, they had moved him into an accommodated position before eventually they were going to put him back in the breeding tech position. But again, all of that is as a result of the 2015 injuries that had nothing to do with his back injury in this case.
Well, the same restrictions were in effect before this injury as after this injury, correct?
Correct.
That's part of the problem, isn't it?
That is part of the problem. Yeah. And in fact, that gets to, and it addresses both the wage and the task loss. I think it most predominantly affects the task loss in this case. And the biggest reason why is what the court, or not what the court, but what the legislature has told us is we're not just looking at what task can the claimant no longer do that they could do in the 5 years prior. You have to look at what tasks the claimant cannot do that the loss is caused by the injury. In other words, what the statute tells us is any tasks which would have been excluded or which would have been lost due to restrictions that were pre-existing the current injury must be excluded from that task loss. And the reason why, again, Your Honor, why I feel that this is the argument here is because if you look at the evidence from Dr. Hess, he did not consider the pre-existing restrictions at all. If you look at the evidence from Mr. Thomas, which is a vocational expert from the claimant, he did not consider the pre-existing restrictions at all. And if you don't consider those pre-existing restrictions, then how can you determine what is a new loss from this injury? The board did not do that analysis. The claimant's experts did not do that analysis. And without that analysis, the decision that follows and the conclusions that follow cannot stand under the statute. The same applies to wage loss when you look at what wages can the claimant no longer earn. It's not just what can he earn currently versus what did he earn before. What was the nature of that loss? Why did he have that wage loss? If he's restricted under the prior restrictions and he can't work as a result of those, and he has that wage loss because of those restrictions from the 2015 injury, you can't then conclude that it's on the current employer for the 2020 injury. So with that, I see I'm about out of time. If there are any questions, otherwise I'll yield.
Very good. Thank you.
Thank you.
You may proceed.
Thank you. My name is Jeff Cooper and I represent Sergio Martinez. We believe the order from the Workers' Compensation Appeals Board, January 8, 2025, awarding a 55.5% work disability is supported by competent evidence and follows Kansas workers' compensation law and should be affirmed in all respects. Just some brief background. Mr. Martinez is 55 years old. He has 6 years of school in Mexico, no other schooling. Can't speak or write English. Worked for Haverkamp Brothers for several years, starting in 2008. His job involved maintenance, cleaning, feeding, breeding, inseminating, care of farm animals, primarily swine. Past 25 years, his only job has been on a farm. It was stipulated or agreed that Mr. Martinez sustained a work-related injury on November 23rd of 2020. He injured his back after falling downstairs. Mr. Martinez had a prior injury in 2015 that council referred to, which resulted in a 6% permanent partial impairment to his left hip and knee. There's some reference about prior restrictions. I don't believe those are in the record. That wasn't submitted as part of the record in the case. The evidence supports that Mr. Martinez returned to work doing his regular job duties following the hip injury. Following the
When would that have been? When did he return after his 2015 injury?
I didn't write that.
Was it years later?
I don't think it was very long later. I think he returned. I know he was there before 2020 when COVID hit.
Oh, that's because they were still trying to clarify and work out what his permanent restrictions would be?
I don't know that they ever did that. That's the question I have. There's nothing in the evidence about what his prior restrictions were.
So you couldn't tell me what his prior restrictions were after the 2015 injury?
I don't believe so. I think his testimony was he returned to work doing all the job tasks, including the breeding the pigs. And then following this injury in 2020, he was off work for 5 weeks, and then he testified he was brought back to his regular job. After returning to
Well,
work and
at
trying to do the job,
Excuse me, at that time, was his regular job light duty and office work?
no.
You're saying he returned back to breeding hogs?
That's what he testified to, and I think that's what the evidence is. And he did return to 8-hour day instead of a 10-hour day. There's some testimony about that. But Mr. Martinez testified he reported pain and physical problems and asked to be relieved of 2 tasks involving the breeding of the hogs, which was problematic physically for him. That was about 50% of his job. The board held it was clear that the claimant, Mr. Martinez, did return to work full duties as a breeder tech, and his complaints of pain increased following his return to work, and that's what he testified to. He testified that at times he would leave work early because of the pain and discomfort, and responded knew about it and allowed him to go home.
I'm sorry, are you saying that he never was on light duty?
I'm sorry.
Are you saying he didn't work light duty?
I think the only time he worked light duty was during the COVID time. His testimony is he basically was working as his regular farm job the entire time, except for a period of time he was doing the COVID stuff.
It wasn't as a result of restrictions from the first injury?
No, according to his testimony, no, he returned to the same job. He was terminated from his job on October 21st of 21. He testified he was terminated because the owner and supervisors needed someone who could do 100% of the job, and he couldn't do it. His understanding was that since he couldn't do 100% of the job, they no longer needed his services. He was never written up. There's some testimony and some comments made about leaving work early. There's no reprimands, there's no warnings, there's nothing. There's no evidence to support that he was terminated for cause. He simply said, I couldn't do the job, and they didn't have a job for him. So if you look at no facts of any bad faith on Mr. Martinez's part.
And no facts of bad faith on the employer's part either. I mean,
No, I think he just couldn't do the job.
did this essentially come down to a credibility call on the part of the board as to which doctor to believe and to whose testimony to
Right.
believe about what his job was when?
I think, as I'm going to say in a minute, there's plenty of evidence that the board had to form their opinions based on. I think it's all credible evidence, and the judge could pick. We had a doctor who said he couldn't work at all. He had a 10-pound weight limit. That's a board certified neurosurgeon that said that. The respondent sent him to a physical medicine doctor, saw him one time, and said he had a 3% impairment due to SI joint problems, which was clearly refuted and rebutted by the court-ordered doctor, who said he had a herniated disc.
What standard of review should we use then?
Well, I think the law is you look at the evidence, and as long as the board applied competent evidence in arriving at their decisions, and we believe they did, that the decision should be affirmed. I would point at time of trial, the only issues remaining were whether or not, what is the nature and extent of his impairment, what was his disability, and future medical. Those are the only 2 issues that were decided. Everything else was agreed upon. It was agreed upon, stipulated he had an injury by accident that was the prevailing factor causing the problem. As I said, the claimant alleged that he was permanently totally disabled, given his age, his lack of education, his work history. Really couldn't go back and do any of the jobs that he'd ever done before. But the judge decided he was not permanently totally disabled and awarded him a work disability. The appeals board reviewed the decision, and the appeals board has the authority to review de novo all decisions, findings, orders, and awards of compensation pursuant statute. And
Well,
they
looks-
reviewed that.
Yeah, they did. But it looks like what the board did was, as to wage loss, sort of did its own calculation. Because the vocational experts were one was 0%, one's 100%. What's the judge going to do? And he averaged them.
Yeah, and I think that's exactly what they did. They looked at all that and said, well, if he's not permanently totally disabled, he's got to be able to work somewhere. And they said, well, we think he can do a minimum wage job. And so they imputed a minimum wage job to him of $290 a week.
You've had experience in workers' compensation cases, haven't you, counsel?
Yeah, a few, yes, sir.
Ever seen them impose averages before?
Happens very frequently, Your Honor. And I think that's kind of what the board did, is they looked at it and said, hey, you know, what's reasonable under all the facts and circumstances. They had all the doctor's testimony. They had the vocational experts. And they felt, well, he could still work. And he probably the best he could do with a sixth grade education and no prior work experience is a minimum wage type job.
What should we do as a court of appeal when reviewing such a decision?
I think you review all the evidence in the case, which I'm sure you'll do, and find that the appeals board looked at all the competent evidence, considered it all, and they come up with their decision. And it is supported by competent evidence.
Your opposing counsel makes a point, though, that they were restricted to only because you can't mix your injuries. You've got restrictions as a result of the first injury and now the second injury, and it's blown it out of proportion. What's your response to that?
Well, response to that is this gentleman really didn't have any restrictions the first time, and he continued to work doing the same job. If you look
That's
at,
a pretty serious injury when a 400-pound hog rolls over on you and you have multiple surgeries afterward. You're saying he didn't have any permanent? There's no record he had, in the record, it doesn't show he had permanent work restrictions after that?
not that I'm aware of it, there's nothing in this case that I'm aware of that shows what the permanent restrictions are. And he continued to work doing the same job. I think pretty much everybody agrees up until this injury happened. And his testimony is he did the same job, and by doing the job after this injury, he has problems, can't do it, and asked to be given an easier job, and the employer just didn't have a job for him. I'm not faulting the employer for that. I mean, he is really limited on what he can do. But I don't think anybody displayed any bad faith. I think, you know, he hurt too bad to continue doing the work, and they weren't able to accommodate him.
So if we focus on task loss, we have doctors, you know, one that included the task loss from pre-existing permanent restrictions, and one that excluded all of them, Dr. Hess and I think Dr. Wheeler. And the board found neither one of them credible.
Well, I think they split the baby on it. I think they're exactly right. I think, yeah, Dr.
Well,
Hess.
I guess I have a question on that, because don't you have to have a licensed physician to make the determination of task loss? And so if you have one saying 0% and one saying 100%, who is supporting the 50%?
The judges took it upon themselves to find that there was a 50% task loss based upon all the evidence. You're right. Our vocational expert, again, depending on which doctor you use, he said based on the doctor's Hess's opinion that he had 100% task loss.
So we could say that the board erred because they should have made it 100%.
That's
But the-
one possibility as well.
But the
Yeah.
board made express credibility findings that neither one of those doctors was credible.
Yeah, I think
What do we
that's
do
what
with
they
that?
said. They didn't think either one of them were completely right, and that's why they went with a 50%. And I think the board has the ability to do that based upon all the evidence in the case. They can come up with a finding of task loss and finding of wage loss, which they did.
What would be some evidence supporting a 50% task loss resulting from the 2020 injury?
Well, certainly you can look at the claimant's testimony and what he says he can and can't do. You can look at the tasks themselves and look at the vocational experts and how the doctors interpreted those tasks. If there's a 10-pound weight limit and the task requires lifting 30 or 40, clearly that task is
But we don't have those facts, do we?
facts.
About what weight he had to do his normal job, or even what his normal job was at the point when he,
Well, I
fell
think
down the
both the
stairs.
vocational experts talked about what his job tasks were in his job, breeding the hogs and taking care of the hogs, feeding them, et cetera.
so did
There's
he
a
have,
task list, yeah.
but did it talk about how much weight that would require him to do that task?
Oh, yes, yeah, the task list will include all that, sure.
Okay.
And you kind of anticipated my next comment was just going to be on the task loss. Again, there's evidence of somewhere between 0 and 100, and the board picked 50. Finally, with regard to future medical treatment, Dr. Hess says will need additional treatment. Dr. Jones says he needs additional treatment in the form of medications. There's also, Dr. Gardner referred him to a surgeon on his back. So there's evidence that there is a need for future medical treatment.
Well, there's
And I-
also evidence that there isn't. I mean, Wheeler said he didn't need any. He was at maximum medical improvement. So
I agree.
did the board make a credibility finding or?
I don't think they found her to be credible. She saw him 6 months after the injury, one time. She's not an orthopedist or a neurosurgeon. And I think you can base opinion on medical treatment based on the fact that the claimant continues to have pain and medications appropriate that Dr. Jones recommended. So we think the evidence does support a finding of future medical being left open. We assert that the evidence is substantial and it covers all the elements and supports the decision of the appeals board and should be affirmed in all respects.
I do have one question for you on future medical. Is it correct that your client went over 2 years without medical care and treatment after the 2020 injury?
Well, I think he saw doctors for quite a while after that, but he testified he's getting pain medications from his family doctor. Of course, work comp doesn't pay for that, but if he's taking pain medications for that, then, once this case is resolved, if his medical's open, he'll pursue additional medical care related to that.
What's your position on whether the rebuttable presumption was triggered that he doesn't need future medical care?
You only have one doctor that says that. You've got two that say otherwise. So I think the weight of the evidence supports what the board found in terms of future medical treatment. And I'm about out of time, but I'd be happy to stand for any questions. If I had some more information, I wanted to. In light of the record as a whole, we believe that this issue should be affirmed.
Thank you,
Thank you.
counsel. Counsel, you may proceed.
May it please the court. I wanted to respond just quickly to the comment that was made a couple of times concerning whether or not there are prior restrictions in the record, and there certainly are.
From 2015.
From 2015. It's been cited in our brief, which again, I understand the court will read, but throughout the record at volume 2, 16 through 17, volume 7, 73 through 74, volume 9 at 10, Dr. Mullen was the treating physician on the 2015 injury. Dr. Mullen gave restrictions for no crawling, no kneeling, no climbing ladders, infrequent squatting, occasional lift or carry of 35 pounds, frequent carry of 15 pounds, constant lift or carry of 7 pounds, push or pull occasionally of 100 pounds, push or pull frequently of 50 pounds. It goes on, but my point though is there were clear permanent restrictions on the claimant. That was from his authorized treating physician on the 2015 claim. For the claimant to argue today that he did not have permanent restrictions from 2015 is false. There were. Those restrictions carried forward through the work that he was doing for Haverkamp up until his termination.
But does your client contend that he could have done the hog breeding job with those permanent restrictions?
They believe that he could have done so. And that's relevant here because if they couldn't accommodate, well, that's relevant from the standpoint of what restrictions are on the 2020 claim. We're not talking about the 2015 claim in terms of can they accommodate those or not, because it doesn't impact this case. It really doesn't. What restrictions are from the 2020 claim are actually about the same or less. So from that standpoint, can they accommodate those? And their answer was yes, that they could. In fact, they were at the time that this injury occurred. The other thing that I wanted to address is what duties the claimant was doing. You can look at the claimant's own testimony. He was not doing his regular breeding tech job duties on the date of the injury. He was doing the cleaning job. That's unrefuted. You can look at what weight the board placed on the individual experts. And I think if you truly look at the decision that's been put before the court, the court didn't really look at the credibility of each. What the courts, or excuse me, what the board said is, well, each side did their respective roles. One was for one side, one was for the other. But that's not the end of the analysis here. It's not just that one expert was hired by one party and one expert was hired by the other. Dr. Wheeler looked at the pre-existing restrictions. Dr. Hess did not. And I don't see how a credibility determination can stand if the full analysis isn't being done to determine the credibility of the two. And it comes down again to interpretation and application of the statute, which I believe is the standard that would be applied here. But even under a substantial evidence standard of review, there is not substantial evidence that supports the board's decision on all three of the issues that have been raised. Thank you.
Thank you, counsel. Appreciate the arguments. We'll take the case under advisement and get you a written decision when we can. The next case on our docket is 128836, Gary Washington, appellant versus the Topeka Rescue Mission, appellee. I'll take your appearances when you're ready.
For the appellant and plaintiff, Gary Washington, Bruce Allenbrum. Thank you.
Good afternoon, for appellate, the Topeka Rescue Mission, Michelle Stewart.
Thank you. Mr. Brumley, you may begin and let me know if you would like some rebuttal time.
I have 15 minutes, is that correct?
Yes.
Let's go 10 and 5, please.
All right. 5 minutes rebuttal.
May I begin?
We'll wait for our clock to give you your full 10. Now you may.
Oh, I see. All right, I'm ready. Thank you, Your Honors, for hearing my case today. It's not very often I get to put on a suit anymore with the post-COVID rules. What you have before you is a slip and fall case. Most of the facts are pretty unconverted, but what we're arguing for is an extension of the mode of operation rule. I know you read our briefs, and I watched you ask questions on the previous case, so I hope I'm ready for any questions you may have. But in a nutshell, we're asking for basically the original determination in the Jackson case to be the rule for the state of Kansas. The next case was Hempy. It was a Court of Appeals case. There is some language in there which seems to restrict it to self-operated modes of operations.
Like self-drink stands at the quick shop or in a,
Yeah, the traditional
Hamburger place.
examples would be like you get a drink and the person getting the drink, not the business, spills it. And then from that mode of operation, if they just let it go, there's spills all over the place and they fall.
Mhm.
And in Hempy, I hope I'm pronouncing that correctly, I believe it was against Walmart. The plaintiff lost because they had a reasonable, foreseeable mode of operation in which they would check for falls. And that's, I think, why you see in grocery store cases, we have slip and fall, you get all this evidence about whether or not they had.
I've got a facts question for you
Yes, sir.
in this particular case. Do the parties agree that this slip and fall was due to water on the floor from a baptism?
I believe so.
Well, you say yes, and I see a head behind you going,
No?
no. So tell me why what's in the record that says this was from a baptism, this water was from a baptism? As I understand, there's showers out there, there's a bathroom, the water could be from leaky pipe, but you say it's from a baptism. Tell us why.
I believe it was in the uncontroverted facts. I mean, I know from talking to my client, but I can't introduce evidence at the Court of Appeals. I would say this, though, if it was disputed as to whether or not it was a baptism, we certainly argued that it was in our brief to the judge down below, then you would have a fact question that would get you past summary judgment. In this case was thrown out on summary judgment from Judge Bedford. So that would be a fact question, I suppose a jury would have to answer. But I have more, even if it was.
Well,
for-
you're asking us to extend the mode of operation rule.
Yes, sir.
It seems to me that the mode of operation rule is in existence because there are certain businesses that conduct business in such a fashion,
Agreed.
that water can get on the floor, ice can get on the floor, things can fall on the floor and people can slip and fall. So there's an increased possibility of falling and injury, correct? And that's why
Yes.
the mode of operation rule is there. So I want to know why you think that that should be extended here in the case of a baptism, if that's what the water was from.
Yes. I see I spent most of the morning reading about the mode of operation, and it seems to be based on foreseeability, you can't talk, based upon your operation in conjunction with the acts of some third party. Okay. So, and when you read it in the restatement of torts, or you read it in Jackson, it doesn't limit to self-service operations. So in this case, the business, if you will, being the mission, you have services provided to homeless people who come in, and it isn't controverted that it was a religious establishment. That's only relevant to the issue of the baptisms. I'm not knocking religion in any means, but and they performed baptisms, and clothes would get wet, and as in this case, which is in the facts, and clothes would be hung up, and water would drip onto the floor.
Where? In the dorm room, in the bathroom, where?
I believe it was a hallway. I
Clothes
believe.
are hanging up in the hallway?
It is a homeless shelter. It's not, a Hilton, yeah. Clothes were hung up by some other third party. That it wasn't by Mr. Washington. It wasn't by an employee or volunteer of the mission. It was a third party who, if I remember correctly, is unknown. It may be known. I don't know. I don't know if it's even relevant. But one more question, response to Judge Hill. You indicated it could be from a shower. Well, that's also part of the operation of a mission. So if it wasn't a baptism, I don't really like saying so what to a judge, but it's still part of the mode of the operation of providing shelter to people, and wet clothes is part of that operation, whether it be from a baptism, which I believe it was.
Shower with your clothes on, counsel?
Well, clothes can still get wet from a shower. No, you don't. That's a great question, and I appreciate it very much. It was clever. But you're still in a shower where there's water, where it's undisputed a puddle was caused. Whether it be from a towel or clothes or whatever, there was a puddle. Nobody's disputing that.
I'm trying to see a mode of operation here where we could expand this. Do you have anything, is there anything in the record that says, well, they got 15 baptisms a day, or they got 10 baptisms a day?
I wish there was, but there's not.
Is there a record that says they require baptisms, that they
don't.
encourage baptisms, or they permit baptisms?
I argue they encouraged it.
But is what evidence shows that?
I don't think they required it.
What evidence shows they encouraged it? Any testimony, any documents,
No, I don't believe we have direct testimony saying that.
any circumstantial
The fact
testimony?
that there wasn't much testimony, there was the plaintiff's deposition and his affidavit that he provided in his response to the summary judgment motion.
Isn't that pretty important for the mode of operation rule, though, when you're trying to tie this third party's acts into liability to another entity, the rescue mission, that you have to show that that was the mode of operation of the rescue mission, that they either, the baptisms were their idea, or they encouraged it, or they required it. I mean, that's the tie we
I think
need.
there is evidence that they encouraged it.
Well, I'm asking what that evidence is.
And yeah, I understand. And it's a good question. I'm probably going to blow through my time, but I'll just keep going. Okay. Do you need to reset it when that happens or? Is it-
We'll just eat up some of your rebuttal time unless you want to quit.
No, it's fine. Well, to answer your question, and I was looking at the unconverted facts before I came up here. There were unconverted facts related to the website with the mission. An objection was made as to relevancy. I think that objection was made related to the religion part not being relevant, which I agree. But they still went ahead and marked that fact as uncontroverted. And so the mission of
But that doesn't get you there. I know a lot of religious institutions that only sprinkle for baptism. You know, unless you're showing their dunkers, you know, submerged, you're going to get your clothes wet. I mean, you don't even have that fact, do you?
No, I do not have testimonies. I'm not going to be distruthful to your honor. It's not in there. I wish it was. But what I do have is a place where people live. Undisputably is part of the mode of the operation of the place. And we had wet clothes, for whatever reason, hung up in a place where people walk. The mission sizes it's not like there's 2 or 3 people there. There's a lot of people there at the mission. So it would be foreseeable under that mode of operation that there would be wet clothes for whatever reason, or clothes that need to be hung. And it would be our position that the mode of operation would have to account for that foreseeability of puddles in the living area or where people walk.
And you're wanting to rely on the mode of operation and the foreseeability piece because the alternative is notice, and it's uncontroverted that the mission had no notice.
Yeah, that's why we're here today.
Right. So without that expansion, you're done.
I agree.
Okay.
That's my argument and trying to make it. So I will reserve the rest of my time. How much time do I have?
You're at 0. That's perfect timing for your rebuttal.
So I have the full 5 minutes or?
Yes,
I doubt that I'll need it, but thank you.
very good.
The phone. That might be important. Good afternoon, Your Honors.
Hello.
I think we need to start with what the actual facts before the court are. And those are, they are governed by the record. And Supreme Court Rule 602A4 requires the appellant to provide a proper record to the Court of Appeals when relying on that argument to support their position on appeal. And here, clearly, plaintiff has not. Most egregiously, there is absolutely no record evidence that supports the Topeka Rescue Mission performs baptisms, requires baptisms, encourages baptisms, or recommends baptisms at its shelter. The record isn't long. It's about 78 pages, and there's not one factual piece of evidence to support those facts.
Does that water come from a baptism or what, do we know the source?
We don't know, Your Honor, and that's a very good point. And what the uncontroverted facts is that after the plaintiff's fall, someone reported and said, hey, I just got baptized today. I hung my clothes up and that water might have come from me. But the critical point was that the water was not on the floor for any longer than the plaintiff walked to the restroom from his bed. He said he was in the bathroom only long enough to use the facilities and brush his teeth. And then when he came back, there was water on the floor. And the district court correctly found or granted summary judgment because it's uncontroverted, there was no notice of a dangerous condition on the property, which is the rule, actual or constructive notice. There's no dispute that the rescue mission did not know there was water on the floor, did not have an opportunity to cure it. And that's the general rule. What plaintiff argues for to expand the very limited, very targeted mode of operation rule would essentially open a Pandora's box to any business who opens its doors to the public. That's plaintiff's argument.
Well, I think it's narrower than that. He's saying they by putting hooks in the hall or letting you hang your clothes in the hall, they might be wet. It's foreseeable. People are walking in the hall, they're going to slip and fall. So he's still talking about the same slippery, wet floor by a third party that's the reason for the rule in Jackson. So I don't think it's as broad as you're saying.
Well, but Your Honor, what the point in Jackson is that foreseeability notice. And that's why it has been narrowly tailored to self-service type operations where customers are allowed to come browse and select and choose their own merchandise, of which there is no dispute the Topeka Rescue Mission is not. It has to be foreseeable. There is no evidence before the court that it was foreseeable that someone would be hanging their clothes on the back of a bunk in a dorm room that happened to be wet that would create water on
So
the
it
floor.
was in a dorm room, not in the hall?
Yeah, that's correct. The record evidence in the testimony was that he was walking back to his bed in the dorm, the men's dorm, and that's when he slipped and fell.
So it's not a common area.
Correct. And I hate to say not common area, but it is because it's a shelter, right? So it is an open dormitory style. So it is a common area that residents of the men's shelter stay in, but it's not.
And not little bedrooms in there.
No,
Beds,
of bunks.
correct. Lots of bunk beds, lots of, areas for people to walk, but he wasn't in the hallway walking, for example, from the restroom that he was in back into a different room. It wasn't a common walkway area. It was in the dormitory. That's where his fall happened. And so there is no evidence that it was foreseeable that residents would be hanging up wet clothes on the back of a bunk and then there would be a puddle of water on the floor. There is no policy. The rescue mission doesn't have some sort of policy that you can't do that, which also lends itself to it supports the rescue mission's position that there was not foreseeable that this would happen. There's no evidence that it ever happened before, that they had a common problem with people leaving soiled clothes on the back of a bunk or a bed. And the Topeka Rescue Mission it's not a self-service operation. They're operating a shelter serving homelessness, hunger, poverty, and persons of trauma, and they are sheltering them. And extending this mode of operation rule would essentially say, well, if you come to the rescue mission and you happen to get hurt, I as a plaintiff don't have to prove notice. Or any business that opens itself up to the public, you get past that. That's why the mode of operation rule is very targeted and very narrow, because it relieves a plaintiff of their requirement to prove actual or constructive notice of a dangerous condition on a business's property.
Not all states have the mode of operation rule.
They don't, Your Honor. And that's why Kansas took it from this Arizona case, but has very narrowly applied it in Jackson and all of its progeny. It is very targeted and it is very limited. And again, the facts of this case do not support this expansion.
Is there any argument that could be made that we should expand it?
Absolutely not, Your Honor. It would open, again, I would contend it would open the Pandora's box, and it would, as plaintiff describes it and argues for, any business that opens its doors, if you happen to slip and fall because a third party caused a problem to exist or caused a defect or a danger on the property, the business owner or the proprietor is liable. And as this court held in the Ramsey case, that would really subsume the entire negligence claim, which is why it is a very targeted, very narrow exception, the mode of operation. It looks to the mode of how the business operates, that mode of operation, to allow the exception to apply. So again, we're talking about a very narrow exception.
It would be an anomaly, would it not, for an intermediate court of appeal to find policy?
It would, Your Honor.
That?
It would, and it would require this court to abrogate the holding in Jackson. And the record is, again, devoid of any evidence or facts that requiring baptisms, baptizing people was part of the mode of operation of the Topeka Rescue Mission. Simply because the Topeka Rescue Mission is a Christian faith-based operation doesn't allow some inference that it is foreseeable that persons seeking shelter there would be baptized or would go somewhere and be baptized. And to Your Honor's point, there is no evidence before the court as to what type of baptism was performed. And more importantly, no evidence that any baptism was actually performed at the Topeka Rescue Mission, or that it was those clothes or a puddle of water from those clothes actually was the puddle of water that the plaintiff fell on. That is simply the only evidence that was brought to the Topeka Rescue Mission after the fact, was another resident saying, hey, it might have been me. But again, this is not something that well, this happens every day at the rescue mission. And so we should know that the puddles of water would be on the floor in the dormitory areas. It simply just doesn't occur.
So when he said it might have been me and he said he'd been baptized, did he say he'd been baptized at the rescue mission?
No. He said,
He
I
didn't
had
say
been
where.
baptized. He did not say where in the report, but there is no evidence in the record that the Topeka Rescue Mission affirmatively performs baptisms, requires baptisms, or encourages baptisms. And again, to allow some sort of inference that someone had gone and been baptized, that it was required by the rescue mission or done by the rescue mission would be improper because that's not the evidence before the
Well,
court.
it's not too far from the river up there.
Could have been done there. We don't know. But the Topeka Rescue Mission, the evidence is, does not perform baptisms, require or recommend them. It was not aware of a particular risk where soiled or wet clothes would be hung on the back of a bunk and water would accumulate on the floor. And again, for the mode of operation rule to apply, it is that business's choice of how they operate their business. And there is simply no evidence in the record that the Topeka Rescue Mission operated its mission in such a way that would allow for puddles of water to accumulate on the floor of the dormitories. In fact, again, the uncontroverted facts in this case was that there was no water on the floor when plaintiff left his bunk to go to the restroom, was in there for a very limited period of time, came back and the water had, then there was a puddle of water that he slipped in. So there was no foreseeability that water would be on the floor. And even did not exist. It wasn't a condition that existed for long enough for the rescue mission to have notice. And the reason Kansas courts have made the mode of operation a limited exception, again, goes back to the fact that you are relieving a plaintiff of proving that actual or constructive notice and allowing a business an opportunity to cure, or in the case of a supermarket, to pick up the, vegetable that's gotten on the floor. It is very limited and it should not be expanded because it would be contrary to the laws of the state of Kansas, and it would essentially result in strict liability to any business owner. And the district court in this case correctly found that there was no actual or constructive notice of a dangerous condition on the property of the Topeka Rescue Mission and properly granted summary judgment. He also district court correctly found that the limited mode of operation exception does not apply to the facts of this case.
Well, basically, for premises liability, one has to have proof that the proprietor knew of the dangerous condition. Is there anything in this record that shows that whoever operates the Topeka Rescue Mission knew of this water on the floor?
No, Your Honor. In fact, plaintiff admits that's uncontroverted, that no one knew or even had constructive knowledge, knew or should have known. That point has been conceded even in this appeal.
So the mode of operation rule expands that so they don't have to have notice because they should have had notice. They realize that they're allowing things that could lead to slips and falls happen. And so that's waived.
Yes, by the way a business, that's why it's limited, by the way that business operates, it is foreseeable that third parties will create a dangerous condition and allow accidents to happen.
It's not absolute liability. It is basically a waiver of the notice requirement.
Correct. Which would relieve a plaintiff from having to prove actual notice and that opportunity to cure or rectify the abnormally dangerous condition on its property. And the defendant, Topeka Rescue Mission, would request that this court affirm its decision granting summary judgment in the rescue mission's favor based on the facts of this case and not expand the limited mode of operation exception in this case. And I'm happy to answer any questions, but I feel like it's a very succinct point. And so if you have any questions, I'm happy to answer them, but otherwise I will turn my time over to my opposing.
We're good. Thank you
Thank
for your
you.
argument.
All right, I'm ready.
Okay.
First, as Judge Hill pointed out, we're not asking for strict liability in any means. The mode of operation rule resides on foreseeability. If you read both restatement of torts, that's what they talk about, what I read this morning. That's what Jackson talks about. And I'm not asking you to overrule or expand Jackson. I'm asking you to if you're overruling anything, it's Hempy. I don't even know if you're overruling that. I'm asking you to expand the mode of operation rule to all businesses. And no, I don't think that's an unreasonable thing to request. We're not asking for anything that happens to make them liable. We're asking for foreseeable third-party actions to account for some mode that protects people from falling or being injured from the business you operate.
Well, it might be a reasonable request, but to make it to our court, which is duty bound to follow Kansas Supreme Court decisions,
Yes.
is sort of the rub.
Well, if you read Jackson, they don't specifically say it's limited to self-service businesses. They just state the rule. That came from the Court of Appeals case. And this is the Court of Appeals. You can change that. I mean, you're not bound by other Court of Appeals cases. You can modify that. So it's within your jurisdiction to do so. I did want to address one other issue, and I have 3 minutes and 20 seconds left, so I wanted to get to that. You asked me where it was in the record where it could have been a baptism. And I fumbled poorly on that question, but I have the record. It's the accident report that counsel was referencing. I believe it was an exhibit which we didn't controvert, so it would be an uncontroverted fact in the record. And this is an amendment. It's called Second Incident Report. I wish I could give you the pages of the record, but I pulled it up on this, so I can't. What it says is this is an addendums to yesterday's report. After making my report Sunday, Joseph, and I apologize, I can't read the gentleman's last name. It starts with a D, came to the front desk and informed me that he felt bad and responsible about Gary Washington falling. Then it says JD, which is the gentleman, said he had been baptized earlier that day and he hung wet clothes on the end of his, I think it's supposed to be bed, but it looks like bank. And it says he believes that Gary slipped on the water from those clothes. So even though I fumbled before in my initial time period, there is evidence in the record which suggests that baptisms do occur. I don't have evidence that talks about the frequency, but
Well, nor evidence that it occurred there. He could well have been baptized
does
at
it
another church, at a
matter?
church
where-
or somewhere else.
Does it matter where it occurred if it's foreseeable that you're going to have wet clothes?
Well, it has to be the mode of operation of that entity is foreseeable,
Yes.
not of some other
And
entity.
I think, and I don't have a cite, I only had 10 minutes to correct what I did on the original argument. That there's enough foreseeability there that a jury could address whether or not baptisms are foreseeable at a Christian run. And I'm not knocking Christians, for goodness sake, a Christian run mission where people have baptisms. Also, with my 53 seconds moving very fast on this clock, it is a shelter where people are living. There's going to be puddles for one reason or another. And it's undisputed, there's no policy within their mode of operation to address puddles. And I think it's reasonable to impute as part of their duty of foreseeability that they have some other method to account for the people that are in there. They're homeless people. I'm not knocking homeless people, but they're unpredictable as to what they might do. It's foreseeable that there's going to be puddles. And I think a jury can make that determination too. So as I'm down to 12 seconds now, I would ask that you simply remand it and that we have a trial on that issue. Thank you, judges.
Thank you, counsel. We appreciate both your arguments. We'll take this case under advisement and get you a written decision when we can.
Thank you, Judge.
Our last case on the docket today is 128861. I think it's Juan Gibson, appellant versus Dan Schnur, appellee. I'll take your appearances when you're ready.
May it please report, Mr. Gibson appears not, but by counsel Wendy Miller.
Thank you.
John Grace appears on behalf of Warden Schnurr.
Thank you, counsel. Appellant, you may begin and let me know if you'd like any rebuttal time, please.
Would like to reserve 2 minutes of rebuttal time, please.
2 minutes. Very good. You can do that.
Well, let's talk about a chair today. The first issue that we've raised in our brief is the issue of whether there's some evidence to support the disciplinary violation that Mr. Gibson was convicted of in the case involving the shakedown of his cell in January of 2023. So an officer had been ordered to do a shakedown of the cell. And during this shakedown, he looked at Gibson's locker and bed, and he didn't find any kind of contraband in the locker or bed. There was, according to the reporting officer, contraband that was the size of a ping pong ball, half of the size of a ping pong ball, in a sock that was pulled up over a chair leg, which the reporting officer indicated was a common area.
But was it, or
Also-
was it in their bunk room? Help me visualize
Now
it.
that's a good question, because in the hearing officer's notes, she indicates that the chair was next to Gibson's bunk. However, there wasn't any testimony that the chair was next to the bunk. And so I can't tell you where the chair was, if it was even, I guess, in the room. We know that this area was an open dorm, that the chair where the contraband was found would have been accessible to all the inmates in the dorm.
You're saying it's an open dorm, did you call it?
Well, that's what I'm calling it. I'm not sure if it's called a dorm, but it is the area that he was housed in, I believe, is open. And at least the chairs that are in use, many of them in the area have socks on the legs to stop noise from when the chairs are being shuffled around. But I think that's a fact that I would like the court to look at, is that we don't really know from the testimony or what the hearing officer indicated. She indicated that, or he or she indicated that they relied on Pettyjohn's information, that he basically had intel that Gibson was in possession of contraband. And so it was not revealed by anybody that Nunez or Pettyjohn were going to be witnesses in this case. So Mr. Gibson did not request assistance by staff to help him with questioning in this case. So that's one of our second issues, is we have an issue with notice. Wherever there's going to be the use of a confidential informant, which didn't become known to Mr. Gibson until he was in the midst of a 1501 proceeding, arguing that the contraband on the chair in the common area wasn't sufficient evidence to show guilt. It was revealed in the KDOC's response that there was a confidential informant. And so
I have a question about that though, because I guess, and I'll just be upfront, I have a hang up with the fact that he was offered the opportunity for this to be sent back down to the disciplinary, for a disciplinary hearing, and to redo this hearing, where he would then have the advantage of staff assistance. And I guess connecting that question then into what we're here for today, assuming that we would find some kind of violation, isn't the result that it goes back to the disciplinary hearing for this hearing to be held? So
well, that's one remedy.
we can't give him anything. Well, and fair, that's probably another question I have too, because you have alluded to some cases where maybe there's an alternative outcome, but there's not really ever a situation where the alternative outcome you recommend has been achieved. And so, but going back, I guess, to the first part of my question then, since he was given the opportunity to redo this hearing with staff assistance and he declined to do so, why is that not, I guess, the end for him in this case?
I think factually that this case is definitely different than the cases that we've cited in our brief. And I think that three significant cases is Shepherd versus Davies. That case cites to Dedrick versus Wallman, and this is all within our brief. And then the Broussard case is also in either our reply brief or our main brief. But these three cases, they're similar, but they're dissimilar. And so the reason I think he was wanting dismissal and expunction and not wanting to send it back down for a new hearing was because in this case, there was no evidence of a confidential informant. And so if the evidence that was provided, from the confidential informant was what information that the hearing officer based Mr. Gibson's guilt on, I don't think starting back over from scratch would be the proper remedy. I think that if there had been evidence presented at the hearing that there was an informant and maybe there was a question of reliability with the informant, and then maybe a new hearing or an additional hearing where the reliability is established would be the proper remedy. But I think because there was no evidence presented on this informant that there even was one. So what we have is we have a chair with contraband in it that the reporting officer considers common area. We don't really know where it was because we don't have witnesses that were testifying. It was right beside his bunk. I didn't see anywhere in the hearing officer's notes where the agent Petty John had testified that it was located beside his bunk. I didn't see where it was. And that's part of the other due process issue that he has is that this informant's credibility was not assessed prior to the hearing, because had he have known there was going to be an informant, he could have requested the staff assistants who could have then challenged that informant's reliability by asking questions for him.
But isn't that dealt with a remand? I mean, I guess and again, I'm just trying to be upfront about my hang up with this particular case, because in other instances where there's due process violations, it's not just set aside, it's remanded. And so I'm struggling with why we would do something different with this set of facts.
I think where there was no information presented about the informant in the hearing, that remand would not be the proper remedy, that it would be dismissal. Because had it been a case where there was some evidence presented by an informant and Mr. Gibson had been made aware that there was an informant, and it was just a question of, as further establishing the informant's veracity, then that would be a remedy. But I think here, because of the specific facts here, because there was no information about an informant at that disciplinary hearing, that starting anew and having a new hearing is not the option. Additional information would be good if he would have known there was an informant. And I think that's the distinguishing fact here. And I don't think any cases that I'm able to find yet specifically address certainly this set of facts and the remedies. We know from looking at the Shepherd versus Davies case that expunction is a remedy. And we believe in this case that that's what the remedy should be. And we think that because there was no information about an informant that was presented at this disciplinary hearing to begin with. And part of there was a citation to Shepherd versus Davies in our brief that cites to a case called Dedrick versus Wallman. And in that case, the court was considering the written findings in a disciplinary hearing, and it was considering written findings concerning the guilt determination. And in that decision, the court talks about the argument that a supplemented record would avoid potential harms is not a compelling argument under the facts of the case in Dedrick, because the court was doubting whether the additions would be accurate. And it was certain to the court that they would almost certainly be post hoc rationalizations. This type of error, the court indicated in Dedrick versus Wallman that this type of error would not be harmless and expunction would be required for it if there was an inadequate finding of guilt. And I understand that the facts are dissimilar here, but one of Gibson's concerns was that if there was to be another hearing, it was his position that coaching of the witness or witnesses may be an issue if there was a new hearing. And so I think
That's something that could be explored at the new hearing. Why does that absolve him of, he was offered and he turned it down?
he did.
And there are consequences for that choice, isn't there?
I think there are different remedies that the court could apply. And I think dismissal, expunction would be the remedy that should be applied here. And that's again, because there was no information from an informant at the hearing. If there had been some testimony about the who, what, where, what is this information that they had about Gibson that caused them to shake down this bunk. If we had something from the informant, but maybe we didn't know the informant's reliability, then I think a remand for an additional hearing might be the remedy. But I think in this case, because we didn't have any information about the informant to begin with, or that there even was one, that expunction would be the remedy here.
I guess I did just want to ask one last question as your time is running out. The disciplinary hearing found the violations and then imposed some consequences. He was removed from the wing. He had some seg time, but it was really the $10 fine that gets us here today. Is that correct?
That's what creates the
Yeah.
liberty.
So absent the $10 fine, we're not even talking about this case at all.
Right.
Okay, I just am making sure. Thank you.
Thank you. And if there's no further questions, I will pass the case to Mr. Graves.
Thank you, counsel.
Feel like I'm the last speaker at a day-long tax seminar. You're having to sit here and entertain, tolerate me for this last day. If it please court, my name is John Graves. I'm here on behalf of the respondent.
Mr. Graves, would you mind pulling the microphone over? You're a little hard to hear. Thank you.
How about now?
A little bit better.
Thank you. I can speak louder too, but the first thing to look at, and I think I've never run across this before, so I'll say it's first for me. Supreme Court Rule 6.02A4 requires the facts to be key to the record. What makes this kind of unusual is that 4 pages of appellant's fact statement and 2 pages of their legal argument are all based on a document that was stricken by the judge from the record. And I'll just bring that up and suggest that you consider whether or not that makes those statements without being properly keyed to the record.
Remind me what document that was? What document was that, sir? I can't remember. That was stricken from the record.
It was an amended petition.
Okay, thank you.
And Mr. Gibson does write extensively and expresses all kinds of things that are being taken as fact.
So even though the court, though, struck the amended petition, it still seemed like the court made findings based on some of what was alleged in the amended petition. Do you agree with that?
I can't say that without going back and really checking the record. We had at least 3 different hearings with him. The first hearing was a lengthy hearing. And that was all on the record.
Okay, thank you.
So, yes. Moving beyond that, I just wanted to comment for the first time I ever ran into that. We've talked about the chair a little bit. The nature of this is a dormitory type setting. So inmates, although they're supposed to be restricted, they do have the possibility of moving into somebody else's living area. They normally, I don't recall if this was at the East Unit, at the East Unit or the South Unit, but these dorms are all set up with a hallway and usually a cubicle where the inmate will sleep. There's usually somebody with either an opposing bed or a bunk bed right there. There's a little desk and there's a chair.
So two people in that area.
Usually two. I think this record talked about three, which I'd have to see how that was laid out, but they're all about the same. And yes, people move around, but that doesn't, and this is a case of a non-exclusive possession. So it wasn't in his pocket. It was on his chair. And the proximity.
Sock on a chair.
There was.
It was a sock on the chair. Is that right?
That is, as explained, it's a little noisy and most of the floor surfaces are either tile or concrete. So the inmates will put socks on the chair legs. It also makes an excellent place to hide things. And in this case, it's not correct to say that there wasn't testimony about where the chair was. There was probably all sorts of testimony taken. That is not a matter of record. Those are just informal hearings where the hearing officer gets statements. The hearing officer did make the only finding of record in his decision that the chair in question was beside Mr. Gibson's bed. And that's your evidence. Now, one of the cases that we cited on a non-exclusive possession was Shirazi, which is another Hutchinson case that may have been at the same dorm setting. It was at one of the two places. It's one of my cases also, so I remember that. And the comment, I don't know if you want to call it dicta or if you want to call it a pronouncement within the case, was that just the fact that other people have access to the area where, in Shirazi's case, I think it was a desk, was located, doesn't make the hearing officer's decision devoid of evidence. So, it's still there. Maybe it impacts how the weight you might give the evidence, but it doesn't eliminate it as some evidence, which of course is your standard.
Pretty low standard.
Yeah, it is. It is. And just to touch base on a little handful of things here, the witness not being listed. The hearing officer initially just writes a disciplinary report. He doesn't necessarily know who the witnesses might end up being in this unusual case. But the hearing officer showed up at the hearing. Hearing officer provided testimony. Mr. Gibson didn't want to ask him any questions. The intelligence officer showed up. Mr. Gibson didn't ask him any questions. And he explained that they had, quote, intel. I hate that word intel. It doesn't tell us anything. And that's what we're talking about now. We don't know what intel means. Did it mean that we had the guy that was in the bunk next to him telling him all this and didn't want to get beat up? Does it mean that they intercepted a phone call? Does it mean that there was a note found in someone's pocket?
It's maybe intentionally vague.
Could be. And if you do get into the nature of intelligence, all you're likely to find in a worksheet like that is a number and perhaps the vaguest of descriptions that the person provided information in the past and they're reliable. You're not going to get any detail about it. And if somebody were appointed as a staff member to represent the inmate, he may, at most, he'll see something like that. There's not going to be any challenge to the credibility. That's simply what the officer that took advantage of the intelligence was. But, if the thing was, there was some suggestion that this was some sort of top secret intelligence that was being used, wouldn't you decide that the fact that they went to where the guy was located and it wasn't in his bunk and it wasn't in his locker, but there was this half a ping pong ball full of meth and fentanyl in the sock right by his bed? That's pretty good intelligence. And the DR is not part of the requirement of the policy is that the disciplinary report, if it's based on confidential information or something of that sort, that it be contained somewhere on the disciplinary report. The report was based on the drugs. It's that simple. This thing is being dragged out of proportion just because that's the nature of trying to parse things further to make an issue where there isn't one. The petitioner's only response was, these guys, we don't know who these guys is, don't like him. These guys want him out of here. We don't know who that is or how they would want to get him. That they may have put the drugs there. I don't know anybody that, once you get drugs into a prison, that wants to gamble that volume of drugs to get somebody else out of their dormitory. But that's his comment. And then they weren't his. That was his total statement. Didn't have any questions, didn't ask anything further. That was what there is. Didn't do it. And then as we go into the appeals process, while other people had access to my room, they might have done that. But that still doesn't eliminate the fact that some evidence in the form of the drugs.
I guess I still have a more basic question of why wasn't he just given staff assistance to begin with? I mean, it wasn't really a secret. They called someone in to testify at his disciplinary hearing that intel was used. So it's not something that was later determined or discovered. Why wasn't he just given staff assistance?
Well, if he would have asked, they would have told us.
Well, but if it's known that, for example, a CI is going to be used, isn't the policy that he is to be afforded staff assistance regardless of his request?
Not in my experience.
I thought there was a regulation, 44.1 or 44.13.408.4.
Well, you're right.
Talks about it shall appoint a staff member if the testimony or evidence will be given directly or indirectly by a confidential informant.
Yeah, and that it wasn't the case.
So intel coming from someone else is not indirect information that's being relayed to a disciplinary officer? Disciplinary hearing
Well,
officer?
we don't know that that was the case. What we know is that this four-letter word intel or a five-letter word intel was referenced, and we don't know what it means. But at worst, the suggestion was this guy might have some contraband in his living area. And there was another case that we had at the Hutch unit, and I think it was at the East unit. And it's actually Starr versus Bruce, 35 Canap 2nd 11 from 2005. That case involved I'll call it a conspiracy of an inmate that was released recently, paroled, and the girlfriend of Mr. Starr, who talked about throwing some drugs and knives over the fence to him. And this came up later. Mr. Starr got a disciplinary report for his trouble, and the person that was recently released and was now back in custody was asked about this. And the comment, again, it's more dicta. Indulge me for just a second here. It's more dicta, but it said there was no confidential informant, but rather a jailhouse interview with a recent parolee who corroborated the results of telephone monitoring. This, in a reverse sense, this suggestion that there might have been some contraband found at this guy's location wasn't a charge. It was a suggestion there might be something there, and there was. But the evidence is not the statement of the person that there might be something there. Officers get tips all the time. The fact that sometimes they pan out, sometimes they don't, really isn't something that policy speaks to. I mean, I know that's not a perfect answer, but it's the best one I've got.
No, and I appreciate that. It just seems to me to go back to if there's a statement made in particular, which is the example you just used in the case that you implicated, that still then calls into KAR requirement that staff assistance be provided.
Well, and that gets around to due process.
Right.
And due process, you've got four things. 24 hours time to prepare the case, a written decision that explains the basis of the case, the opportunity of the party to the case to present evidence and testimony, and that they receive a fair hearing. And it doesn't guarantee a perfect case. We know that. So that's,
Can you have a fair hearing when the policies are not being followed?
well, we've got lots of policies, and I'm sure we don't, most of the hearing officers are not terribly well experienced. This one that would have heard this case he was a good hearing officer and is still in that role. And he tries to follow the policies. He's not perfect either. But I don't think in this case that it really meant anything, because it really impacted the decision, because the fact that the intelligence officer did appear and testify, and the fact that the reporting officer appeared and testified, and Mr. Gibson didn't want to know anything about it. Worst case scenario, as you've pointed out, Judge, remand the case. I suggested that because I really sincerely want the inmates to feel like they're getting a fair shake. And I thought that's okay, that he's made a point. I don't know what the answer is. Let's kick the case back, give him an opportunity to have a do-over, find out what he can.
And he declined that option.
The first hearing, I'll say yes, but to explain, the first hearing that we had was a lengthy hearing with the judge going over so many times, multiple times in the record, that if you want me to decide the case today, there's probably going to be found to be some evidence to support the hearing, the decision of the hearing officer. And if you want to remand it to have some further examination of the intelligence issue or whatever it is, then I'll do that. It's up to you. And the case then continued on past that for multiple hearings. Finally, an attorney was appointed to represent him. And finally, he just said, I want you to go forward today. Go ahead and decide it.
And again, over a $10 fine is why we are here today.
I have thought more than once that I would give him the $10. And I've been told ethically I can't do that for some reason. But, yeah, we do sometimes battle over what seems to be small issues. But, within the prison setting, people get into fights over chunks of cardboard.
Well, and it's on his record, correct? I mean, it's not just over and done.
The only way that will impact him is when he gets to the point of being released,
Yes.
that'll be used in a computation for how many good days of good time he may
Yeah.
not have. And that's already been done in in his next review. So thank you for listening to me. Have a good afternoon.
Thank you, counsel. Ms. Miller, you have 2 minutes.
Thank you. When looking at the some evidence question in the Shirazi case that was cited, and I think between the two of us, we've probably cited most of the sufficiency cases that are the leading cases, but in the Shirazi case, inside his desk, there was evidence that was connecting him to the desk. And so there was contraband, but there was also evidence within the desk that they could connect him with this desk. And so here, there was nothing connecting Mr. Gibson with the evidence, and I'm not too sure.
Was it his sock? Do we know whose sock it was?
We don't, we don't know. But I would just say that there was no connecting evidence here and ask the court to look at it. And as far as the intel, I'm not sure if they said that it would be that contraband would be found in a chair. Or if the fact that the chair was next to his bed was a conclusion that the hearing officer made, because there wasn't anything as far as notes on testimony that's, I didn't see any notes or anything in the record to suggest that there was specific testimony that this is where the contraband would be found. And then as far as the amended petition, that is correct, that the court, that was struck from the record. But the district court did make the due process findings, concerning arguments that were in the petition. And with my time being up, I will conclude the case unless there's a question.
Thank you, counsel. Thanks to both of you. We appreciate the arguments and we'll take the case under advisement and get you a written decision when we can. And I believe that concludes our hearing, all of our business for this afternoon. So court is in recess.